Thank you for those who have zoomed in today. Thank you for joining us. On behalf of the Sandbox Center team, welcome to our Experts in Residence session, The Legal Brief with Barriston Law. And if you haven't attended one of our recently launched Experts in Residence sessions before, we're happy to have you with us today. Across a wide variety of different expertise, we're offering free expert advice to all businesses across the region in order to help support with the economic impact that COVID-19 has currently created. If you're interested in learning more about what our Experts in Residence program has to offer, feel free to head over to our website, sandboxcenter.com, after this session and check it out under the Programs tab. Today, we're thrilled to have our experts, Chris Holmes and Cassandra Ironside from Barriston Law, join us to speak on the topic of multiple wills, estate planning, and how it can benefit small business owners at this time. They'll be answering any burning questions you may have or clear up any confusion you may have when it comes to the topics. So just a quick thank you to all of our community partners for supporting with the sharing of our events. And of course, a huge thank you to our sponsor, Barriston, for delivering today's session. So without further ado, I'll hand it over to Chris and Cassandra to get us started.
Hi, everyone. My name is Chris Holmes. As Mackenzie had mentioned, I'm an associate lawyer at Barriston. I practice in the areas of real estate, wills and estates, and corporate law. And then Cassandra is an articling student at Barriston, and she's helped me prepare this presentation and will help answer some questions along the way. So what I want to touch on today is really estate planning as a whole, with a focus on estate planning for small business owners, particularly people who own corporations. So to get to the benefit of what multiple wills are and what they do, first I just want to go through more generally wills, executors, and powers of attorney, and then other estate planning tools that are common, such as joint tenancy, designated beneficiaries, and the creation of trusts. So what is estate planning? It's a process. It's not just a will, it's the whole process of looking at what you own and thinking, what do you want to happen to this after you pass away? Some things can be done while you're alive, others can't be done until after you've passed away, but there's a lot of steps you can take while you're alive, not only to save money on taxes, which is always, first and foremost a concern for a lot of people, but also just to structure things to make it easier for everyone, because no matter how well you prepare your estate, it's going to be a difficult process for those left behind. It's always more work than people think being an executor, and just dealing with banks. Something that should be fairly straightforward can often take weeks of emails and phone calls and in-visit bank appointments. So effective estate planning can not only help make sure the people you love get and the benefit of what you've worked your whole life for, but also just make their lives easier with the whole process. So it's not a one-time task, it's a lifelong thing, because every day we buy and sell new things and our estate changes. So just because the estate plan might be right today, 5 years from now, 10 years from now, you might need an entirely different estate plan. And the law changes frequently. So at the very least, you're going to want to look this over every so often and make sure that, not only does it still reflect your wishes, but it's also still legally valid. So estate planning is not just a will, like I mentioned. It also includes things like joint tenancy, designated beneficiaries, and the creation of trusts. The will is the cornerstone of a good estate plan. It should always be in place for every Canadian. I know a lot of people say, oh, I'm too young, I don't have kids, I don't own a house. Regardless of this, everyone should have a will. They can be as general and basic as you want, but once again, just having that in place really helps with basic things like appointing executors and setting out who gets what you own, because the government has a set statutory scheme for distribution of estates. And just because the government thinks that's how things should go, doesn't mean that reflects your family life or your family. And the people you think might be getting your estate, like a common law spouse, wouldn't have any entitlements under the common law. And the will should be used mostly as a catch-all. So anything that can be dealt with through other means gets dealt with in the will. And then we want to create as many strategies as possible to basically make your will deal with as little as possible. So if you look at this chart on the next slide, this kind of sets out what the will does. So your estate's everything you own, which is this big circle. And then the will is executed by the executor. and they transfer all that property to the beneficiaries in accordance with the will. And when you use techniques like joint tenancy and designated beneficiaries, if you go down to the next slide here, you can see that that can pull assets that you own outside of that estate, so outside of that bubble that's dealt with by the will, and essentially move assets to your beneficiaries, sometimes without tax implications, and otherwise just outside of the will, meaning it doesn't need to be probated, and I'll go through what probate means in a little bit. But essentially, if two people own a house as joint tenants, then on the death of the first person, that whole house goes by right of survivorship to the second owner. If you own it as tenants in common, meaning 50-50 as separate shares, on the death of one of the owners, their half of the house goes into the estate. It'll need to get probated, which costs money and takes time, and then it can finally go to the beneficiary, who might be the person who owned that other 50% of the house. And designated beneficiaries, this only works for registered plans like RRSPs, TFSAs, and that is actually just appointing someone on the plan itself as your beneficiary. So that's something that we can do in a will. So it is dealt with in the will, but doesn't necessarily form part of the estate, or you can deal with it directly with your investment advisors or the bank. So the most common thing that you need a will for is your primary residence or your home that's just in your name. This will almost always, except for with a few exceptions, fall into your estate and need to be probated if it's just in your name when you die. So the pros of a will is a control of the assets during your lifetime. So just because you give to someone in your will, it doesn't affect your ability to deal with the property at all. You can gift someone your house in your will and then sell it the next day, and that gift just disappears from the will. You don't need to update your will. If you don't own the house, the gift doesn't exist anymore. Beneficiaries never pay taxes on inheritances. So any capital gains that have accrued, there's no inheritance tax. They get it tax-free. Any taxes are paid by the deceased estate. So any capital gains you've accrued on, let's say, a cottage property, that will go, your estate will have to pay those, and then the beneficiaries will receive the property without any tax implications, and their cost of the property will be the value as of the date of death. And inheritances are also excluded from beneficiaries' net family property. So this is a family law term, and essentially is the bundle of property that's divided on a separation. So as long as it's not intermingled with other family property, such as you get a cash inheritance and you pay down a mortgage on your house, that would be intermingled, and then that money would lose its special status as an inheritance. But if you keep the money separate, then on divorce, that money stays with the person who actually received the money and doesn't go to their spouse. So that, I know parents are often worried about that when their children receive money. And then the issue with the will, so the only real con, and it's not a con because you should always have a will, but if you just use a will as part of your estate plan, just a single will, any real property can trigger probate on the estate. And multiple wills is a good way to minimize probate. It won't necessarily avoid it, but it'll minimize it to the best extent possible. And joint tenancy, I've already talked about this. Basically, this slide sets out the two types of ownership of a property, joint tenants or tenants in common. Joint tenancy means you have right of survivorship. So the other joint tenants, if one passes away, say there's 3 owners, all as joint tenants, the other 2 will be joint tenants to the full property. And then on the death of the second, the last owner will just be the sole registered owner. If they're tenants in common, each owner would own a third of the property. If one passes away, their third would go into their estate. And so the pros and cons of joint tenancy. So instead of gifting something under a will, say to your child, you could add them on property to your house as a joint tenant. So the pros of this is you avoid probate. The property just flows to the child or the spouse by right of survivorship. The cons are if you transfer the property after you've owned it for a while, you'll have disposed of half the property, and that could trigger capital gains. So there might be some upfront costs to doing that. However, there's always you're going to pay that capital gains cost no matter what. The property will always appreciate. So capital gains is something you can't really avoid. It's mostly just delay tactics. So that shouldn't be seen as a total con. And then the other con is that if you transfer property to a child, then they are a part owner of the property. unless you use what we call a bare trust agreement. So if you and someone else are joint owners, you each have a 50% interest, ownership interest in the property, and you both need to agree on any decisions with respect to selling the property, mortgaging the property. However, as in Ontario, we do something called a bare trust. And what that says is that even though two owners are entitled to the property, beneficial ownership of the property is really only held by the person who originally owned it. So say a parent wants to put their child on, not because they want them to have control of the property, but simply for estate planning purposes. We can do this bare trust agreement. And what that says is the child's only on for estate planning purposes. They have no vested beneficial interest in the home. They're only on to avoid the necessity of probate. So this is a valid estate planning tool. We do this all the time. The only downside to this is if you do a bare trust agreement and some other asset drags the estate into probate, because beneficial ownership doesn't also transfer over, you may have to pay the probate costs of the bare trust property. And this is something else that multiple wills can assist in. And like I said, I'll get to that in a minute. Next is, so this is a kind of a more general overview of trusts. So what a trust is the separation of legal title and beneficial title to a property. So this can either happen through the will or while someone's alive. The trustee is the person with legal ownership, so they have control over the asset. However, they don't actually have beneficial ownership. Beneficial ownership means they're entitled to the value of the property. They can use and enjoy the property. So this is often used for minor children. The trustee will be the executor of the will, and the minor children will be the beneficiaries. So the money will be held by the trustees for the benefit of the children. So these can be very flexible. And this next slide sets out the two types. So like I said, this can be created through the will in the example of an inheritance to underage children, or it can be inter vivos, which means during the life of the person. And that'll be something like a trust fund you sometimes hear about, where even though someone's children are adults, they don't want to give them money to live, they want to have some control over it. So they'll settle a trust where the individual will be paid out money, say monthly or on an as-needed basis, but control stays in the hands of a third party or the settlor, who would be the parent who gifted the money. The other beneficial use of trust for estate planning is what's called a Henson Trust. So this is used for anyone on ODSP payments, and this can help avoid an inheritance impacting a person with a disability's entitlement to ODSP payments. So if anyone listening has any questions about that, feel free to contact me. It's fairly complex and fairly specific, but I'm happy to talk about that if anyone has any questions. So now I want to get into probate. So if you can skip down a couple, Cassandra. This is really the meat of the presentation, but that rest was just background to get to why dual wills are important. So probate is formally known as the application for a certificate of appointment of a state trustee, either with or without a will. It's a very wordy term, so us lawyers normally just call it probate, which was the old term for it. Essentially, it's just the court procedure for affirming that the last will is in fact the last will of the deceased and verifying the appointment of the executor. So the executor doesn't get appointed by the probate process, it's through the will, if there is a will. If there is no will, then yes, the court has to approve the person is the proper person to act as the executor. And so this process, it's fairly simple paperwork-wise. The hardest part of it is collecting the value of the estate, because you must ascertain the value of all the assets the deceased person owned before submitting the application, which could include things like getting a real estate appraisal, bank statements of all their accounts as of the date of death. If there's any valuable assets like paintings, those might need to be appraised beforehand. And once it's filed, it could take, lately it's been pretty good in Barrie, it's only been 1 to 2 weeks, but over the past couple of years, it's been up as long as almost 6 months. So this probate process can delay administration of the estate quite significantly, up to a year in some extreme scenarios. And in addition to this, you need to pay 1.5% approximately. There's a tariff, but that's normally what it ends up being, of the estate as a probate fee or estate administration tax. So this is a fee to the government essentially as a cost for having to probate the estate. So 1.5% doesn't sound like much, and it's not a huge tax as far as taxes are concerned. But when it's avoidable, if you have $1 million estate, as you'll see, we have a little demonstration further down, that can become quite substantial. $15,000 is a lot of money to pay when it can be avoided for far less. So probate's only necessary when essentially someone says, we won't transfer this asset unless you give us a certificate of appointment, meaning you've gone through the probate process. So the most common reason it's needed is for real property. So any home only in your name. There's one exception to this called the first dealings exception. It's very rare, and it would rarely come up. But if someone has passed away and they've owned a house for more than 20, 30 years, it would be worth looking into this exception to avoid this. But for most people, any real property just in their name will trigger probate. The other time it's often triggered is with bank accounts. Banks, they set their own limits for probate, but a lot of banks will be in the $100,000, $250,000 range. And if any accounts have more than that amount, they may require that the estate be probated before they'll release those funds. So multiple wills, this is an estate planning tool that it doesn't avoid probate, but it helps avoid the number of assets that need to go into probate. So it consists of two wills, a primary or secondary will, or sometimes called a public and private will. Public meaning it's submitted to the courts, and private meaning it isn't submitted to the courts for probate. The primary will deal with things like bank accounts above a certain amount in the deceased's name, real property or publicly owned shares or other things that someone will require probate to transfer. Things included in the secondary will are first dealings property, which is that small exception I touched on, any private corporate loans. So this is why it's really important for small business owners, is that if you only have one will and you own a property just in your name, the value of all the shares you own in your business will get dragged into the probate application, which not only becomes difficult because now it could be up to a year before anyone's able to really validly control the corporation. It'll just be your estate trustee needing to manage it on your behalf. But you'll also need an appraisal of your company, which is extremely costly, especially if you're audited. You'll want to make sure there's good records supporting the valuation you put through for the probate purpose. And so it could be quite damaging to a company to need to value the company and hold up really control of it for almost a year while the principal owner has also passed away. So to preserve that value in the company, putting this into a secondary will essentially allows you to take the will into the lawyer's office who prepared it and say, we need to transfer this. They gifted the shares to this person. Can you update the minute book of the corporation and the registers to reflect this? And it takes a couple of days. It's a lot less than a year, and there is no probate fees associated with it. The secondary will would also deal with things like personal effects, jewelry, furniture, vehicles, trust property, and then literary assets, meaning things like, not many people own it, but if you own copyrights, things like that, it'll handle things like that. I see a question here on, do multiple companies require multiple wills? So no, the use of the term corporate will, it's helpful for conveying what the idea is behind the secondary will, is that your corporate shares will be encompassed in it. But it's not really a corporate will. Corporations don't die, they exist until they're dissolved. The will is of the shareholder. So no, when we do corporate wills, it covers, we normally will name the corporations you own at the time you've drafted the will, but we'll also set out any other corporations owned by you that can be transferred without probate. Those shares will fall within your secondary estate, dealt with by your secondary will. So you could own 1 or 100 companies, and you just need the one secondary will to deal with all of those.
And Chris, did you see the other question? It says, how do my shares get divided? And then tax implications.
Okay, and so for the shares, that is entirely up to you. You can either gift them to a specific person, or they can fall into the residue of your estate to be divided as the trustee determines among all of your beneficiaries. So, whether, say there's 100 shares and there's 4 children who all get the inheritance, they each get 25, or one child, wants to run the company, they take 100 and then buy out the interests of the other ones. That's the benefit of doing a will, is it's as flexible as you want it to be. You could make it a very convoluted distribution scheme, or just very simple and say, my trustees decide which of my 4 kids get these shares, and just everything's going equal. What assets make up that equal division, that's entirely up to my trustees. So you can have as much or little control as you'd like and you feel comfortable with, or just say, my 1 child gets all the shares, the rest of the 3 kids split everything else. In terms of tax implications, capital gains would be payable on death, like I said, with the like a cottage property or something like that, where you'd have to pay capital gains unless you claim the exemption for that. And your estate may be able to claim some exemptions. It's really more of an accounting question, but in terms of taxes for the beneficiaries, there would be no tax implications for them. It would just be the tax on your estate. And once again, that can't be avoided. It can be delayed, but someone will pay that tax eventually. And that's where, in order to minimize taxes going forward, there's a number of strategies we can use in conjunction with accountants to reorganize corporations and preserve some of the current value of the company and the owner now, and then issue some new shares to the children or spouse or whoever is intended to be the successor of the company, and have them start growing equity in the business now. And that helps minimize the tax expense to your estate and can help in corporate succession proactively, as opposed to reacting after someone's passed away. So that's something a lot of people will do. And once again, if you want to talk about that, I'm happy to discuss.
All right, Chris, there's just we've got 2 more if you want to keep going with questions here. There's one that says, where is the best place to put your home or cottage in regards to wills?
So I'm not entirely sure what this question's asking. Your home or cottage would fall under your primary estate, most likely. Sometimes if cottages have been in the family for a long time and nothing's been done with it, they may fall under that first dealings exemption. So we often will look beforehand and potentially set out that the cottage falls in whatever will it ends up needing to. So we try to move as much as possible over to the secondary will. But likely it would end up your primary will and would need to be probated to get transferred. Like I said, there's other strategies that could be used, such as a trust for the cottage while you're alive, or putting the cottage in joint tenancy through a bare trust agreement with your children, your spouse, or whoever you want the cottage to go to. So there is no best place. It's specific for everyone on basically where you want the cottage to go, how long you've owned the cottage, and how much control you want to maintain of the cottage while you're still alive. But yeah, depending on that, I'd be happy to discuss further, but it's really a fact-specific determination. But there's many different ways to structure dealing with cottages. It's quite a common thing that arises in Ontario.
Just another one for you, Chris. What impact does out-of-province recipients, foundations, or non-residents have on multiple wills, estate planning, and corporate succession?
So in terms of non-residency, doesn't have an impact in terms of Ontario law because there's no inheritance tax. There's no real impact in terms of being a beneficiary living out of province. The biggest issues with being out of province in terms of an executor is that there may be a requirement to post bond, and that's basically an insurance that you're not going to have the assets transferred into your name as an executor and move and leave the province where the courts can't enforce any actions anymore. So if you have an executor, preferably you'd appoint someone in province. The main concern for if you're out of country, there may be some issues with if they become the sole shareholder, it may no longer be a Canadian controlled private corporation. That would also depend on who the directors are. So there would be a bit of a mix. It would need to be some legal and accounting advice there to deal with how that would impact taxes. But in terms of just being a beneficiary out of province, there's no real impact there. And then it looks like there's another one here. So this person is requesting they're the only owner and director of a company, and what happens if something were to happen to them, they would need someone to take over. So if you're the sole owner and director, and you haven't dealt with anything in your wills, if you've prepared a will, your sole beneficiary would become the sole shareholder eventually, and your trustee would be the representative of your estate, meaning that they have control over all of your assets, including your shares, which means they would, in an interim capacity at least, control the business. Preferably, if there's a concern about any health concerns, you may want to start planning that now, perhaps appointing a second director, so that if you were to pass away, the second director would be in there to step in immediately and start taking control, potentially even your trustee being that person if that's something they're willing to do. And then you may also want to issue shares. If you want to start succession planning, you may want to issue shares to that person. And that would be a discussion both with your accountant for tax advice purposes, and then us for actually, giving effect to that issuance and giving someone else some interest in the business. You could also just appoint someone in your will as the beneficiary of the shares. Say there's a longtime employee, or none of your other beneficiaries are interested in taking over that corporation. You could always give the option for someone to buy out the interest in the shares so that your beneficiaries get the money, but they don't necessarily get the corporation because they're not in a position to run that. So once again, it's a very flexible thing with a will. You can make it as in-depth as you'd like. So the next question, there's one here. If I'm an estate trustee and I don't know the details of the deceased estate, where do I start? It's always a good question. Normally it really just involves, if you're going through their home, just trying to find whatever documents they might have with banks. You can always talk to a lawyer. We can do searches for things like real property, but there is no database for wills or for bank accounts. So sometimes we'll do a notice to creditors if necessary. That doesn't really help you with what the deceased owns. It only really helps you find who the deceased owes money to, which is also important as an executor, making sure that you know what's owed and you make sure all the debts are paid from whatever assets there are. Other than that, it's really just a lot of legwork trying to figure out where they banked and talking to the bank managers there. And it's often difficult. Many people think it'll be a straightforward thing pulling this together, but people don't keep as good records as most of us would like of what they owned and where they banked. So it's often a fact-finding mission that involves a lot of going to banks, a lot of phone calls, just trying to find out what's out there.
Chris, have you ever had someone ask you about the tax return, starting with that document?
For the estate return?
Just the person's individual tax return beforehand. If you can start there, maybe it does designate that they have shares.
Yeah, there may be investment returns, and you would see if they had an account or an RRSP, you would see that say TD issued them an income slip that has things, investment income from TD, and that at least gives you a starting point, knowing that there was some money held in TD. So you can contact TD. You'd likely need a copy of the will, and then they're always reluctant. Banks are very privacy focused, but eventually most people are able to get through, and it happens all the time. So yeah, once you've found that, you should be able to get into touch with someone at the bank that can at least say, yes, there's an account here. You may need to probate the estate first before they'll talk to you. It all depends on the comfort level of the bank.
Right. And often during our instructions, we ask these types of questions. I mean, people can change banks and open and close accounts, but at least those notes may be of some use moving forward.
Yeah, so often when we've taken will instructions, we don't take down account numbers because, like Cassandra said, they change all the time, but we at least make notes of each bank, where they bank, what types of accounts they have there, so that, like Cassandra said, if someone comes saying, I don't know what to do, I was appointed and I have no idea what they had, we can say, well, 5 years ago they had this, this, and this. Go look. They said it was at this branch, look up the phone number and give them a call. There's a question about the tipping point to consider drafting dual wills, cost versus benefit. So if you're simply looking at cost and benefit, the tipping point would be the cost for dual wills, you would generally look at, it might be around double the cost of a very simple basic will with no other, complicated estate planning tools in there. So in terms of monetary cost, you can try to determine how much value is in your estate, what would likely need to be probated, and then what's 1.5% of everything you own and 1.5% of just your house. And if that value is, more than the extra cost of the dual wills, then purely on a money basis, it's now, cost benefit analysis, it's better. And obviously there's a difference between you paying the money in your estate. But the benefits, there's a lot of kind of soft costs and extra costs to look at, such as a corporate valuation, a real estate appraisal. All these things likely will be necessary for real estate unless the first dealings exemption applies. But for other things, to value a business, can be tens of thousands of dollars. So if you own a business, I would often say, yes, I 100% recommend doing dual wills. If you don't own a business, I would still recommend it for everybody. It just, because everyone's estate changes day to day, it's a safe way to make sure you're protected as best you can and minimizing probate fees. But really, I'd say I would completely recommend it to anyone who's a shareholder of any private corporation. If you're not a shareholder, I would still recommend it, but I wouldn't push quite so hard for that. So there's a question about, as estate trustee, do I distribute the estate or does the lawyer do this? So estate trustees are essentially responsible for everything. Lawyers are hired to assist with anything that's properly categorized as a legal job. And that mostly just entails filing the probate application, transferring, the house, if the house is sold, doing the sale of the house, maybe drafting the agreement for the sale if it's a private sale. And then executors are also able to delegate some responsibilities to lawyers. The issue with that is they may lose their entitlement to compensation because you can't really double dip and pay a lawyer for a job while also taking executor's compensation. So, if anyone questioned the compensation taken, that would likely have to come into account and the lawyer fees would have to be deducted from that. But as a general rule, the trustee is the one responsible for distributing the assets, but they can utilize a law firm to actually do the distribution and, cut the checks to the beneficiaries, get releases from the beneficiaries, do things like that. Next, there's a question about how long it takes to distribute an estate. And this is really dependent on a number of factors, including how long the probate process takes, if necessary. And like I said, that can be a week or that can be a year. There's no way of knowing, it can change seemingly overnight. In Barrie, about 6 months ago, it was taking a few months. And then all of a sudden, applications started coming back after a couple of days. So it's all about how backed up the courts are. And a lot of that has to do with, budgetary restrictions and how many clerks they can have working on these applications on a day-to-day basis. The general rule of thumb is executors have a year to deal with the estate, but particular issues can arise that, that it can take up to 5 years. It can take a few weeks if there's really nothing in the estate to deal with. When should I consider drafting my first will is the next question. And that really is now, yesterday. Everyone should have a will if you're an adult. There's never a good reason not to. And it's better to do it before you think you need it than after you really realized you need it. Sadly, far too often we'll get a call from someone's child and their father's in the hospital or the mother's in the hospital, and we go and it's too late. We aren't trained to assess capacity, but we do have to assess capacity as part of our job. And if we have any question about someone's capacity, they need a formal capacity assessment. And that's thousands of dollars and just might not be possible. And even if it's done, the assessor might not think they have capacity, meaning they no longer have the ability to create a will. So essentially it's too late. So the sooner the better. It's a lot easier to update a will after it's already done than draft a new one because everything's on Word. So if it's just a small change, it's a lot easier to change the will and just set up a new appointment and re-sign everything. But yes, everyone should do it right away. And in terms of timing for updates, people should do this roughly every 3 years. I'd say look at it, make sure it still represents your wishes. Obviously, it could be more frequent or less frequent for everyone. Some people change it every 6 months. Some people have one from the 70s and that's their will and they're sticking with it. I wouldn't recommend doing that because the laws do change, not frequently, but frequently enough that a few times during everyone's lifetime, there will be some fairly substantial changes to how estates are dealt with. And how do I know if I need to obtain probate? That's something you likely need to talk to a lawyer about. If someone tells you need probate, sometimes you can push back. If a bank tells you need probate, that's just an internal bank policy. Often they'll be very strict on that and we will need to get probate for that. But if the only asset that will pull the estate into probate is a bank account, sometimes they'll agree after a little bit of negotiating to release that money to the executor. It's really up to the bank's comfort level, but sometimes we can get them to just release that money, and that helps save everyone some time and cost.
Do you
and
find
then
the banks as well, in that case where they're going to give a little bit, will require the executor estate trustee to sign an indemnity? Because essentially that's what the probate is for them. Is that correct?
yeah, so the indemnity is basically saying if anyone comes out of the woodworks and says, why did you give this person the money? He drafted another will after the fact and I'm the beneficiary. The indemnity is the trustee saying, yes, I indemnify you for this. So the bank needs that because their comfort level comes in that court seal on the probate documents, because that gives them, the court's already done, the process of vetting, making sure all the formalities were met. And that puts some more comfort, gives some more comfort to the bank because they can rely on that person as being the true trustee. If it hasn't been probated, they can only really rely on the trustee's word and the will. So yeah, that indemnity gives them a bit more faith that they know if anyone comes after them, they can go after the trustee. So if you're a trustee and you're not totally sure, the probate process might still be the right thing for you, even though it costs some extra money, because it'll give you a bit more assurance that you don't need, if you act fraudulently, they can still come after you. But if you're acting, in good faith, you may want that if you're worried about any fights arising as part of the estate administration process. So I believe I've covered almost everything. The last thing we have here is a little chart kind of setting out just the purely monetary benefits of dual wills. So this first example is if an individual only has one will. So in this example, they own a house, a cottage, share in a CCPC, and that's a Canadian controlled private corporation, meaning most small businesses that are corporations would fall into that category. Bank account, personal effects, and so the total value of their estate is 1.15 million in this situation. So the probate costs would be approximately 17,250. This has changed recently. It's a bit below 1.5%, but purely for example purposes, it would be within that range. And then if you get a dual will, this is how you see the benefit. So out of all these assets, the only thing that would need to be probated in this case is the real property. So the house, and that's $500,000. The cottage, because it falls in that first dealing exemption, and the reasons for that are somewhat convoluted, but just know it's there. If something's been owned for a while, it may be something that can be utilized. So that moves $300,000 out of probate. Private corporate shares, those don't fall into probate, so that $100,000 comes out. Bank account, once again, this depends on what the bank's threshold is. In this situation, it may be, hypothetically $200,000 their threshold to require probate. So they say, okay, it's below $200,000. We're not going to require probate in this case to transfer it into the trustee's name to distribute it out to the beneficiaries. So that's been moved out. And then personal effects never need to go through probate unless they're dragged in. And that's $50,000 out. Oh, sorry, the bank account was included in this one. I'm sorry, I misread that. So
That's my fault, sorry.
yeah, so the threshold in this case was $100,000, which is often what we'd say. So read the bank account there as primary. So now the value for probate purposes would be $650,000, which is the real property and the bank account. So now it's gone down from that $17,000 probate fee to now only $9,750. So as you can see, that's a substantial decrease, $8,000. And the cost of doing a dual will, say it's $500 more, $1,000 more. It's generally somewhere in that range. So just purely from probate fees alone, you've saved $7,000 already. So it's and the larger the estate gets, the bigger benefit there is. Especially if your private corporation's worth a few $1 million, then that $7,000 quickly becomes $10,000, $20,000, $30,000. Okay, so that's really it for the presentation. Do you have anything to add, Cassandra?
No, that was great. Thank you very much, Chris.
Okay.
And thank you so much, guys. I just have a question, actually. What would be the number one advice that you guys would give to SMBs right now, maybe to consider who don't have multiple wills or dual wills or haven't necessarily dove really deep into the estate planning process so far? What would be, in terms of next steps or first steps, what would be your number one advice?
So I find it's always helpful, not purely as self-promotion, but just to speak to a lawyer about it, because people, even if you think you're okay thinking about it, even for me, it's hard. I'm great talking to other people about their estate plans, but to deal with my own, I try to avoid it at all costs. So having an impartial third party there to go through everything with you and really work out what you have and make you think about what you want to do with it is always a really helpful first step. Because sometimes that opens up a much larger conversation where people then, we start going through things and we think, oh, what should we do with this cottage? What are we going to do with the business? Everything's so intertwined with your real estate, your corporation, and your estate plan that really just looking at it from a wholesome perspective, from an impartial person, not thinking about because there's obviously a lot of emotion behind everything, and that's understandable for everyone. But just looking at it without that emotion and having someone talk you through it and confidentially, obviously, and on your side, that's a good place to start.
Awesome. And you guys, has this topic kind of become more relevant? Have you, at Barriston, have you found it, people have started talking about this more because of COVID, to dive deeper into estate planning and have that conversation more? Has it been coming up more, or do you find it hasn't been?
Yeah, definitely. It's definitely the one area that sadly, I guess, is quite busy right now. A lot of people, it forced people to really think on their estate plan, and I think it's for the best. I mean, it seems like for the most part, we've done okay so far, and just getting people to think about it's always important. It's hard to do, but once you've done it, it's done, and you can, avoid it and not have to think about it anymore. It's a lot easier to do while you're healthy and here than to wait too long.